ask council to come forward on case number 124676, State versus GO.
Hey, please the court. I'm Reed Nelson. And I'm representing GO, who was a juvenile at the time. The case is before you on our petition for review. GO had been charged with a number of counts of aggravated indecent liberties with a child. And we had a pretrial hearing where Judge Parrish suppressed his confession after hearing from a couple witnesses and watching the video of the confession twice. And the state appealed. The majority of the Court of Appeals panel reversed Judge Parrish. There was one dissent by Judge Hurst. The issue on appeal, and I think that encompasses the standard of review, which is very important because I don't think that it was followed up until now, is simply whether there are facts and inferences from those facts that support Judge Parrish's determination that this was a coercive interview because the detective misled GO as to the purpose of the interview and also made promises to GO of benefits if he would talk. Those were her findings. That was her judgment. And all we're looking for are facts in support of that. This is not a reweighing, in other words. All parties agree that the detective initially separated GO from his mother to talk with him. And from that point on, it was very light-hearted. The detective is dressed very casually. He sits back, he says, this won't take long at all. We'll have you out of here real quick to go to your orthodontic appointment. And then he begins misleading him. Tells him, this isn't about anybody getting in trouble. This is about trying to fix things. Then he tells him, you're not going to be under arrest. He says that twice. Nothing could have been further from the truth. He then continuously begins to mislead GO as to the nature of the interview, promising that this will help out everybody. My job, he says, and he misleads him on what his job is. This is a detective who conducts criminal investigations. He tells him, my job is to work with little kids. He says, this will help us move past it, and it'll help you and your sister. This is now a therapeutic ploy that he begins to, and uses this throughout the entire interview.
Counsel, let me give you the same hypothetical I'm going to give the state, which is assume with me that the officer had not given the defendant any Miranda rights at all. Everything else is the same. When?
Yeah.
In terms of, do these statements then for sure get suppressed?
Yes, Your Honor. Because this was coercive. The Miranda rights are actually irrelevant in this case. The police cannot coerce anyone, ever. They cannot go on the street right now and coerce someone to talk. Miranda rights are not. Now, he gave Miranda rights, which the prosecution is going to argue, well, that alerted to GO to what was actually going on here.
Right. That's
Right,
that's the red balloon that the Court of Appeals, the majority on the Court of Appeals and the state relies on. I'm just saying, okay, and so for me, that red balloon then has to have a context, which is what fits into your argument. But I'm starting with the premise that no rights had been given at all, and you're saying it doesn't matter because of all the other context.
Coercive.
Okay.
It was misled him. Yes. And the Miranda rights were simply nullified because in the same breath, did you notice in the same breath that he gave the Miranda rights, he said, you're not going to be in trouble? Or something to that. I don't remember if it was you won't be under arrest or you won't be in trouble. I get those confused, but he said, well, Miranda rights tell people that they might get in trouble.
Isn't it essentially settled law that lies during an interview can never rise to the level of unconstitutional coercion.
Can never rise to the level?
Yeah. That the law enforcement has leeway constitutionally to be untruthful.
But I don't agree with that, Your Honor. They have leeway to be untruthful as to the facts of a case. So you can have the suspect come in and say, we find your DNA. And they didn't find the DNA. So they
What's-
can.
What's the difference between that and you're not, my job's to work with kids and whatever else he said?
That's misleading them as to the fundamental legal status of that interview. That is the foundation for everything that comes. That is the Morton case where the suspect was called and said, I'm going to come in. Do I need a lawyer? And in this court in Morton's said that was coercive when they said, you know, come on in. You don't need a lawyer. It's not that kind of interview. That misled him. That was a lie. That was an investigative interview, just like this was, but that misled him. Because that's the foundation for your rights. If you don't know what kind of interview this is.
Isn't that why the Miranda warnings are actually important here?
Yes, well, that's why they would have been important had they not been interfered with in the same breath by indicating that they don't matter. That you're not going to be in trouble. So why would the Miranda rights even matter?
Could we get
Just
back?
under-
No, go ahead, Chief.
Go ahead.
Well, getting back to where you started with the standard of review
Yes.
and what the Court of Appeals did here. It just seems to me then looking at this, according to kind of your view of what the standard of review is, and whether there's facts and inferences that supports the district court's decision in the first place. Talk to me about the reweighing on the educational factor significance, because it does appear to me as I look at it, the district court viewed it in a different light than the Court of Appeals. And
Yes.
where's the tension and the friction there, and why is the Court of Appeals wrong in what they did?
Right. This is the whole problem, Your Honor. The Court of Appeals accepted the invitation to just look at the video and make their own decision. That's what they did. They looked at the video of the confession and they became the fact finder. The Court of Appeals became the weigher of the evidence, and they looked and they thought, well, this child looks like he's reasonably intelligent. We don't think this was coerced. That stepped out of the boundaries of their standard of review. That was a giant step outside the boundaries of their standard of review. They are not the fact finder. Judge Parrish watched that video twice. And not only that, but it was a lengthy hearing where she listened to evidence from the detective
Well,
himself.
and also offered an explanation as to her understanding of the educational significance.
Yes, she considered it. She weighed it. And
Exactly.
she listened to the mother and judged her credibility about all the educational issues the child had. And she is allowed to weigh all that. It is inappropriate for the Court of Appeals to simply jettison all that and say, well, we don't see it. Well, they don't see it because they didn't listen to the evidence. And it was crucial in this case also for fact finder Judge Parrish to listen to the testimony of the detective. Because when you look at the transcript of the testimony of that detective, he is confronted by the defense attorney during cross-examination repeatedly as to all these misleading statements. Even on direct examination, he talks about it, and he never backs off what he said. He never qualifies what he said. Not a single time does he ever say, you know, when I said that he wouldn't be arrested, what I meant was that he wouldn't be arrested when the interview was over or something like that.
So did that rise to the level of a promise?
Yes. Oh, yes. It was definitely a promise. He said, he told him, you will not be arrested.
Was it indefinite? I mean, he wasn't arrested after the interview.
Both times were indefinite. He says it twice. And the first time he says, you will not be arrested when we're done. That's arguably open-ended because he was 2 years later. But then the second time he says, like I said, you're not going to be arrested. Well, he was. And he wasn't just arrested. He was arrested on major felony charges. And even more important, Your Honor, he said he wouldn't be in trouble.
Let's,
except there was an exception. Did say you could be in trouble if you don't tell me everything. And is that important as we weigh the Miranda factor, as we talk about the Miranda factor?
Yes. It's the continual promising that he's not going to be in trouble, that nothing bad is going to happen to him. What reason would anyone have to take their Miranda rights if they are assured by a trusted adult, someone who's acting as a pseudo-therapist, that this isn't that kind of a proceeding? This is that kind of interview. No one would have any interest in taking their Miranda rights. There's no need to.
Why would that? Just big picture, all of this falseness as you're describing it, which I agree with you. I mean, obviously it's a deceptive technique, but why would that prompt a false confession out of this defendant? The one of, not the only, but one of the legal concerns with coerced confessions is that they're false. I mean, someone is getting tortured, let's say, and then they're going to just say anything. To me, this doesn't strike me as, oh, I'm not going to get in trouble, so I'm going to make a false confession to to doing these awful things.
Well, it could, if you think that that person has the power to arrest you and they're not doing it.
So you're postulating that your client may have been sitting there thinking, I didn't do this, but he's going to arrest me anyway, unless I give a false confession.
Well, I don't necessarily go along with that with my client. I'm going to take a step back. I think that's answers your question in terms of how this ordinarily could work. And this is why police detectives don't usually do this, and they shouldn't do this. But in terms of our case, I just stop at the idea that this is coercive. You can't. Is right.
Just
And-
go ahead.
No, essentially, so then under the standard of review, it's our role, as I understand your argument, to just take the findings that the district court made. And then the question for the state then, or to overturn the district court, the state would have to show as a matter of law that these findings, we're assuming they're supported by substantial competent evidence, but those findings as a matter of law cannot render a statement involuntary. Is that essentially the state's burden when we're reviewing or an appellate court's standard of
correct.
review?
Yeah, that's correct. And that's why, honestly, I mean, I think the state's position has to be very difficult in this case because they're not disagreeing with us as to the law.
Yeah, it's not, that's my understanding of the state's position here is, look, we're not disputing any of the facts found by Judge Parrish. We just are simply saying that those facts, as a matter of law, do not render this confession unconstitutional.
And Your Honor, they're not disagreeing as to the law itself. They don't think that the law allows a detective to trick a child. They don't think that the law allows a detective to mislead a child and lie to a child in order to get him to waive his rights or in order to get him to talk, which is exactly what happened here. They don't even disagree with that, as far as I can tell. So they are asking you to reweigh the facts that Judge Parrish already weighed. That is what is happening. They asked the Court of Appeals to do that. The Court of Appeals accepted the invitation, watched the video for themselves, and just started from scratch without ever hearing from the detective. Without ever hearing.
Let me ask it just a highly conceptual question. When we're asking the ultimate question of law, what does reweighing mean? Because there is a weighing component to reaching the ultimate legal conclusion.
Right. There's always that element to it. This is more, to make it simple, what I feel like the job of the appellate courts is at this point is exactly what you set out in your cases, to look for facts and inferences from those facts that support the trial judge's judgment, even if the trial court didn't make the exact factual finding.
Well, isn't it, it's evidence and inferences that support the district judge's fact findings. But if we're really not questioning any of the fact findings, there is still an element of weighing that goes into the legal question. We get this all the time in these, I mean, like Fourth Amendment cases, like reasonable, we always get into this fascinating area where we have a set of facts that we're not going to reweigh, but then we have to consider all those facts in reaching the ultimate.
I think what ends up happening is that you look to see if it's reasonable. Is it so unreasonable? I think sometimes is the factual finding so unreasonable? And I will comment before I sit down that in addition, Judge Parrish didn't need to make factual findings on every single fact. Didn't need to do that. She made 3 pages of factual findings and did exactly what she was supposed to do. I think the state has problems that she didn't make certain factual findings, but that's where, again, the standard of review is that you find facts, you find factual inferences that support her determination. She can be right even for the wrong reason. She can be right for any reason. So it's not necessary for her to make, and the facts were not in dispute below. Prosecution didn't ask her to make any factual findings because they weren't in dispute. The witnesses agreed with each other.
And part of the problem is that the ultimate conclusion, the legal conclusion, voluntary versus involuntary, is just a mushier legal standard than whether or not someone was had the right of way or was running a red light. So does this court then owe some deference to the legal conclusion made by the court? Or is it simply a matter of the state must prove that she was wrong?
Well, but this answers your question. Yes, it is a little bit mushier. But it's driven by the facts and the inferences. I believe this is driven by the facts and the inferences, and the facts and inferences that support her judgment are from beginning to end.
So it's simply that the state must prove that the inferences made by the court finding the statement to be involuntary must be
very unreasonable or something.
Isn't the ultimate standard the totality of the circumstances? That would we look at for voluntariness?
Right, that's correct. Yeah, under the totality of circumstances, and who in a better position to look at those totality of circumstances than the judge who's looking at the credibility of the witnesses in front of.
That's a legal question. Totality of the circumstances is a legal question, which is reviewed de novo.
That is reviewed de novo, considering the facts that support that. Yes, that's correct. Okay. Thank you.
May it please the court, the State Affairs by Assistant Solicitor General Natalie Chalmers. I plan on covering 5 topics if you'll let me, and probably not in the order that I intend. But first, I want to touch on the standard of review. Second, the facts that were actually made, or the factual findings that were made. The fact that Miranda matters, the fact findings that have been manufactured by GO in the dissent in this case, and then maybe RW's application, though I'm undecided on that one. The standard of review, I just heard him say all the facts are undisputed. Okay, then the review is de novo. We take the facts that are undisputed, and this court has de novo review over the totality of the circumstances analysis, which is a legal analysis. My issue has never been with the 4 facts that the district court found. My issue is that those facts do not amount to coercion here. And those facts are that GO didn't have prior law enforcement experience. That's true, but that doesn't amount to coercion, at least by itself. The fact that he had educational issues and he had anxiety, those are probably the 2 most problematic factors in the state's mind. We can't say law enforcement can't interview anyone who has anxiety. I'm not sure how much of the population law enforcement would still be able to interview. The educational issues, I will say, yes, some educational issues on their face. The person's educational understanding is so limited, the officer will immediately know, and that interview probably can't happen. Maybe it's called low functioning autism, something like that. It would be readily apparent that officer would not be able to do an interview. Here, though, the educational issue, which I'm still not entirely sure what it is, if it's the ADD or some other unspecified mild learning disability, the accommodation was one-on-one setting. The interview questions were read to him. Well, that's what the officer did here. We accommodated any possible educational issue. And I don't see how and I think even in his most recent briefing, Gio says he understood the questions. And if you watch the interview, you can see he understands the questions.
I'm gonna step on Justice Biles' toes because he already said he was gonna ask you this, but I'm gonna ask.
We'll be talking about respect for seniority.
Later. Okay. Okay, let's talk about Miranda.
Sure.
Okay, because in your brief, and the Court of Appeals majority found that was a factual finding in support of voluntariness, was that Gio received the Miranda warning. So what is the purpose of a Miranda warning?
The purpose of Miranda warning is to inform you of your rights.
Why?
So that apparently we assume people don't know them so that they can then invoke them if they
And
choose
you
to.
give a Miranda warning when do you give it and when do you not give it? Do you give it when you're the target of an investigation?
Typically, yes, although the Miranda is only required in a custodial interrogation. And
Okay.
so there is some dispute, especially in Shawnee County. I think a judge has found that just being in the police station is a custodial interrogation. So officers will give Miranda even if they think, and I think this officer may have thought this was not a custodial interview, but gave the Miranda warning just out of an abundance of caution.
Okay, so, but is it undisputed that he was the target of this investigation?
Yes.
Okay, so the purpose of the Miranda warning is to say, I pulled up the Miranda warning so I could have it. Where is my Miranda warning? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford attorney, we'll get you one, okay? And then in the next breath say, or even before you say that, to say, hey, we're in this room, so I'm gonna give you this Miranda warning. Or he doesn't even say Miranda warning, I'm gonna give you this, I'm gonna tell you this, okay? To what extent does that even negate the Miranda warning?
I don't see how, hey, we're in a room, but here are your rights, negates the Miranda warning. I do not see that. I understand that that's Gio's argument, that somehow the fact that, well, we're in a police
But
room.
didn't
Okay,
the officer-
let's add to the fact that right after that, 5 or 6 times, he says, you're not under arrest. You're not going to be under
Does
arrest.
not say you're not going to be under arrest after Miranda. I do
Oh,
not
yeah,
believe.
yeah.
He says before,
Immediately before.
immediately before,
He says it immediately before, but he
And
repeats
he
that.
says, he only says the not under arrest thing and I apparently left my transcript in the room, but he says, the first one was, you're not under arrest, or as I told your mom, you're not under arrest. Yeah, I know. And you're not gonna be under arrest when we're done. Then he goes on, and maybe that was after Miranda when he says, like I said, you're not under arrest, and then they keep going. And then Gio immediately starts to mitigate everything that's happened. But the fact that he's not under arrest, again, goes to custodial, not custodial. If you want to say that you're not going to be under arrest is a promise, and I think we need to get there, that is different than, that doesn't negate Miranda. Miranda
Say that.
says,
When you're saying that in conjunction with the reason we're here is because of your sister. We just want your sister to get better. You're not under arrest. You're not in trouble. We just want your sister to get better. The only way you're going to be in trouble is if you don't tell the truth. When you say the Miranda warning, you have the right to remain silent. I mean, to me, it just seems
He does have the right to remain silent. He can stop talking, and he was actually told he could have an attorney present in the interview. He did not invoke his rights.
But why would he invoke his rights when immediately before and several times afterwards, you're saying, you know, you're not in trouble?
He, he only says this isn't about getting in trouble before Miranda. That statement is a before Miranda statement. He then says, we can use your statements against you in a court of law. I think that negates any kind of, this is a free for all. You can get out of jail no matter what you say.
Why is it?
Can you Talk about Garcia. Can you talk about how Garcia fits in with the?
Remind me which one Garcia is. I'm
Garcia is the
sorry.
one where the officer uses the girlfriend. to
Yes,
Say, hey, they're not gonna charge you with first degree murder. So just confess to the other crimes.
right. And here there was no promise. I'm sorry.
Well, and then what I was gonna say, and couple that with Judge Parrish's finding. or Comment at least, and this is in the portion where Judge Parrish talks about what really tips the balance is that Gio believed he was at law enforcement center to talk with Sergeant Hayden about how to help his stepsister, and they go on. And then a few sentences later, Judge Parrish says, talking of the mother, she testified that she told him, talking about Gio, had to talk with the detective. They were all trying to cooperate for the benefit of the stepsister. And does that fit squarely with the situation in Garcia where we way to distinguish Garcia?
No, I don't think it fits squarely within Garcia because apparently, yes, the mom said that she thought they had to talk to him. And I think she said that she told Gio that as well.
And she also told him he would not be arrested. Sergeant had
The
said,
detective said he would not be arrested when we're done. That is actually,
that's not what the mother and in fact, that's when the officer repeats to Gio, he says, your mom probably told you won't be arrested. There was no when we're done qualification.
that's when, but prior to that, he said, like I said, which refers back to the not an arrest when we're done. And my biggest problem with all of this entire conversation is that was argued below and Judge Parrish did not say, yes, I believe he had some kind of promise or benefit. That factual finding was never made. And this court is not a fact-finding court.
But she did say he had no prior law enforcement experience.
Yes.
From that, a whole plethora of inferences can be made, including those, can't they?
I think that's basically this court making fact findings. No, I don't think the fact that he had prior law enforcement experience has anything to do with it. But I think it's also common for law enforcement. Usually they say today, and yes, I wish this officer had said you're not going to be under arrest today. That is common in almost every sex case I ever see, because we don't often arrest in sex cases immediately.
Usually the officer also says after reading the rights, do you waive those rights?
Yes,
And he didn't do that.
right.
Why is it so hard for this detective to just, or this officer, to just tell Gio that at least a part of what he is doing in interviewing him is investigating a crime?
I don't know
Why is
any
that
law
so hard?
enforcement officer that comes in and says, here is what I'm doing. I'm investigating this crime. Gio knew what he was doing when he was there. I mean, how do I know? He immediately knows. He immediately says, without any question at all, I was abused as a child and that's why I did what I did. The entire interview is him mitigating, trying to get out of like, I stopped every time she said stop. Yeah, I would do that. It was him mitigating the seriousness of his actions. He wouldn't do that if he didn't think he was in trouble or he was being interviewed. And frankly, I find it just,
But isn't that
little bit-
fact finding? For you to say you wouldn't say that for any other reason? Aren't there in fact a lot of other reasons why he may have said what he said?
maybe,
He knew his sister was having problems. He knew his sister was making claims. He
but
knew-
how does telling law enforcement
knew
during an
his sister
interview
was-
help him?
He knew his sister was in therapy,
Yes.
and he had been told the purpose of this interview was to help his sister.
And my problem is that a defendant confessing does help victims. And I also find it just entirely unbelievable personally that any 16-year-old thinks a detective interviewing me is the same as therapy. I don't know how we're getting there.
Is that because you have law enforcement experience?
I think even at 16, I'd watched enough Law and Order to know that cops don't just go around being like, hey, I want to have therapy sessions. And this kid is in therapy. He knows what a therapist is like.
The point I'm trying to make, though, is it's not to make,
Right.
we all have to worry, we all have to guard against fact-finding and inference making, which the district court had the total right to do.
Right, but here for the undisputed facts, you either have de novo review, or if in fact there needs to be additional fact finding, I don't think this court should be the one to make every single fact ever. The state did object. It objected when it filed a notice of appeal and it pursued an interlocutory appeal. At that point, if you want additional fact findings, send it back to the district court to make additional fact findings. But I don't think this court is in a good position to say, based on what Judge Parrish found, that she inferred that the mother was used, because that wasn't even argued to her. So how in the world did she make that fact finding?
Why does she have to use the magic words of benefit? That Garcia sets out a 3-part test. And if she made the findings that meet that 3-part test, isn't that sufficient for us? Garcia to say that there was a.
I think she would have had to say something that would have clued in that was a benefit. She said he was there to help his sister. That's true. He admittedly says repeatedly in there that he wants to help her. And I also think that defendants confessing does help victims. It helps them not be gaslit. It helps them think that they're actually what happened to them happened. Does it help him? No. I think the lie here is not that he was going to help his sister. The lie was, even then, he said not about getting anyone in trouble, but the idea that it would help him at all. Because of course, a confession is probably not going to help a defendant, although it could if he confessed in a way that not probably in these kind of crimes, but that maybe he would have done it so that we would have still tried him as a juvenile instead of having him tried as an adult, or his confession would have been mitigating in some way that we wouldn't have apparently charged 60 some odd counts.
They get to use this statement if the officer had not given the Miranda warning.
No, I don't think so here, because there's nothing to negate that you're not in trouble thing. I think that's a problem if there is no Miranda here. But I think Miranda matters here because he says this isn't about any trouble, and then says, but we can use this against you in court. You have a right to an attorney, you have a right not to talk. And that also negates what the mother said. I think in Garcia, the difference is maybe, I don't know if Miranda was given in Garcia. I'm going to admit that I don't remember that case perfectly. But here, after the mom said, you need to go talk to him, he was told you have the right to remain silent and you have a right to have an attorney present in this interview.
So kind of the follow-up of my idea is, if Miranda is that significant, then also the context in which Miranda is given. And that's where the statements by the officer that at least Judge Parrish believed took away from the seriousness of the rights that had just been given to this kid. That's where that's important. So I think it's fair to look at what the officer said and the context in which these Miranda statements were given to determine whether they were effective.
He said, do you understand your rights? Yes. We didn't prevent him from exercising any of his rights. We told him what his rights are so he knew what they would be. I'm sorry, but I just don't see how what the officer did here made him unable to understand his rights, unable to invoke his rights, and unable to stop talking if he didn't want to talk or not have an attorney. Nothing undermined the actual rights themselves, which he said he understood, and there's no indication that he wouldn't have been able to understand that, which is typically where we look at, is something coercive. Was he able to understand his rights? And then was there some kind of, well, it is a very wishy-washy standard. I think even Lefebvre complains about that and the fact that the totality of circumstances is self-standard. I lost my train of thought there.
I'll
You look
jump
like you
in
have a
and ask you a
question, so.
If this court concludes that the Court of Appeals misapplied the correct standard of review, what should happen?
I guess you could do the test for them. I mean, you could correctly apply it or you could remand it back. And I've
Oh,
never
I
quite
guess I'm asking
understood.
which do you think is proper in this case?
Just in the interest of moving this case along, I think it would be great if this court would do it, but I don't understand honestly when you guys do it and when you remand it. That's always seemed like a your call, not a my call. But I think this case has drug on quite a long time, so it would be great if it's allowed. I don't know. If it's not, then it's not. It's the state's position, again, that the fact findings that were actually made by the district court. I think, to me, the first three don't have any effect at all. The one that I think is the issue is whether or not he was misled. And the district court didn't say that Gio was misled. She just said he believed he was there to help his sister. And that factor to her was so overwhelming. There was coercion. And I think Miranda negates any kind of issue with that factor. And so for those reasons, the state would respectfully request that you affirm the Court of Appeals or at least reverse the suppression in this case. Thank you.
Address a couple of the points that were made. I think Justice Biles asked, why is it so hard to just tell a suspect that you're investigating a crime? Well, it's not hard. And that is usually what professional detectives do. I mean, they usually will look at someone and say, we've been told this by this person and we'd like to get your side of it.
Know that. I mean, is that from TV?
Well, I don't know. I just not in the record, but it's argument, Your Honor, it's argument. And the reason why the detective in this case did not do that is because the detective wanted to pull the wool over Gio's eyes. And the detective was concerned that if he indicated that this was a criminal investigation, Gio might not talk. Gio might invoke his Miranda rights. The detective didn't want them. And we're talking about what was said, what was meant in terms of the whole arrest thing. Detectives' direct examination by the prosecution, asked by the prosecution, after you sat down for the interview, what happened? The detective said, we spoke a little bit. I told him that he wasn't under arrest and he wasn't going to be under. Then I read him Miranda. That's how the detective characterized it. And that's what he said. You're not going to be under arrest. So why clear messages talk to me? Nothing bad is going to happen to you. That is the clear message that is being given to a 16-year-old child who is suffering constant panic attacks, who's separated from his mother, who relies on special education in order to graduate. All the other things that Judge Parrish heard, she was allowed to weigh all of it. Thank you.
Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement.